is Usman Sheikh. I'm a partner at Gowling WLG. I'm also, as it turns out, the head of our smart contract and blockchain practice group, which means that I haven't slept since summer of 2017. Feels like it. So we have an extraordinarily distinguished group here today to talk about regulation and the cutting-edge developments in this space. Let me just go through the line and I'll introduce, and then we can maybe have a few more words about your background. To my immediate right is Elliott Mack. He is Senior Legal Counsel, Corporate Finance at the British Columbia Securities Commission. Just next to Elliott is Denise Weeres, who's a Manager Legal in the Corporate Finance branch for the Alberta Securities Commission. To my left is Marc-Olivier St-Jacques, who is Senior Policy Advisor Intermediaries Oversight at the AMF, or the Autorité des marchés financiers. And then to Marco's left is Amy Tsai, who is a Senior Regulatory Advisor for the Ontario Securities Commission LaunchPad. So why don't we start off by giving a little bit more about your background. This topic is about fintech, blockchain, and crypto, and just a little bit about your involvement in that space. So Elliot, why don't we start off with you?
Absolutely. So I'm Elliott Mack. I'm Senior Legal Counsel in the Corporate Finance Department of the BCSC. I'm part of what we call the tech team at the British Columbia Securities Commission. So when exciting new businesses come and have some ideas, perhaps there's a securities law implication, they come in, myself and a person like James Leongit, who's also here today, and you can meet him at the regular session later today, would be kind of the first people to talk to you and kind of work through some issues with you and have a discussion with you. So that's my role at the BCSC, one of many roles. Okay, Denise, how about you?
Hi, I'm Denise Weeres. I'm the Manager of Legal at the ASE Corporate Finance, and I'm one of our two representatives on the CSA's Sandbox Committee. The other is an individual named Mark Franco, who's in our registration side. So I deal with sort of the issuer issues, the disclosure, ongoing disclosure, and he deals with the registration of the dealers and advisors. We don't have a cool, fun name like Fintech or the tech team in Alberta, but we have a large number of people who are interested in the space, and I think our thought is that this is going to be something that's, some parts of it are going to change, but it's here probably for the long haul, so it's something that the entire organization needs to sort of understand and be up to speed on.
Okay, Marco, why don't we hear from you?
Yeah, so Marc-Olivier St-Jacques from the AMF. I'm a senior policy analyst within the registration branch. I'm also responsible for the working group on crowdfunding, marketplace lending, and alternative platform at the AMF. It's part of our larger fintech working group.
Okay, and Amy?
Hi, I'm Amy Tsai. I'm Senior Regulatory Advisor with OSC LaunchPad. We were an initiative that was launched in October of 2017. We were recently made permanent. I think we've got a lot of Ontario-based businesses here today, so to the extent that you'd like to come and talk to us at the networking session, please do. I've got Asad Akhtar in the room, but we're going to be joined by other OSC staff, so we'll have plenty of people available to chat.
Okay, so maybe I should speak a little bit about our group as well. So our team at Gowling's is about 80 to 85 lawyers strong now in the blockchain space, as it turns out. We have a crypto capital markets team, which Jason Saltzman is a key member of. And we actually listed the very first blockchain company in the world and have been on some of the key token sales that have been reviewed by regulators as well. I'm also counsel right now on one of the first enforcement matters involving blockchain in Ontario. So we have a pretty strong team on this panel. So let's start off at the highest of levels, perhaps with the CSA. What's happened, what are the key developments that you've seen over the past year coming out of the Canadian Securities Administrators? And Marco, maybe if I could start off with you. Or
are you going to pass it off to me? Okay, you can start with me.
Start off with Amy, and then let's go from there.
I'll jump in. So okay. I think it might be helpful just to give a bit of background on what the CSA is and what we do. So I think, as you heard during the previous panel, and as most people in the room are aware, securities activities are regulated by province here in Canada. So that means that every local jurisdiction has its own securities regulator. But what we do in order to harmonize our approach to different businesses is we have an umbrella organization which is called the Canadian Securities Administrators, or the CSA. And that umbrella organization really fulfills the dual mandate of investor protection and fostering fair and efficient capital markets. So again, you've got your local securities regulators, and I think as you've just heard, every local securities regulator has, well, not every, but most of the local securities regulators have an initiative in order to support fintech innovation. So you've heard about each of our initiatives. And, you know, we've come together to collaborate really to create an environment where businesses can really flourish not just in their home jurisdictions, but in multiple jurisdictions across Canada, as well as across Canada as a whole, if that's what they choose to do. So what does the CSA Sandbox offer you? So the CSA Regulatory Sandbox is something that was introduced in February of last year, so we've been in operation for about a year now. And what it offers you is the opportunity to really test your products or services on a time-limited basis across Canada as a whole. So what does that look like? It's going to be potentially registration. It could potentially be relief from securities law requirements. It could be a combination of registration and relief from securities law requirements. It'll depend on your business model, but I think one of the key benefits that it brings is it allows you to deal with your principal regulator. So that's going to be the securities regulator in the jurisdiction where your head office is located. And that principal regulator can in turn really help you coordinate the process with the rest of the CSA. So it will have discussions at the CSA Regulatory Sandbox level, you know, help the CSA Regulatory Sandbox get comfortable with whatever approvals you might need. So in practice, if you're an Ontario-based business, you would come to OSU LaunchPad, you would submit a request for support, and you would deal with the OSU LaunchPad team. We would help you work through the business model. What registration do you need? What exemptive relief do you need? And then we would take those discussions and go to the CSA Regulatory Sandbox. So it is really streamlining the process. It's really making it, you know, as efficient as possible for you as the business at the end of the day. And I'll let Marco then talk about some of the activities that we've been doing.
So the CSA Sandbox was officially created on February 23rd, 2017. My daughter was born 2 days after, so I haven't slept since then.
Okay, that's a good date too.
So far, in terms of what we have done in that first year, we've approved 2 ICOs, and we have 4 cryptocurrency investment funds, which are private cryptocurrency investment funds. So these are the firms that are actually officially in the sandbox, but that's really just the tip of the iceberg in terms of work that we do. The support functions that Amy was talking about takes up a lot of our time, meeting with fintechs, understanding their business model, discussing the securities law implication. And also we've been busy with the guidance that we have published to the market through news releases, email blasts. We've published a staff notice on cryptocurrencies back in August last year, which we published in response to the industry, which was seeking greater guidance on what the when would securities law be applicable to ICOs and other cryptocurrency offerings. So, of course, not everything is covered in that staff notice. This is a really fast evolving market. We've heard about it today. So this is why we invite you to come and see us to present us your business model. So we must say, however, that although most of our work so far has been cryptocurrency, we also welcome other business models that are innovative from a Canadian market perspective, and that includes crowdfunding portals, marketplace lender, trading platform. So those models are definitely welcome. So hopefully next year we may talk about these models as well.
Okay, unless there's something else to be, no? Okay, well let's move to initial coin offerings. Token sales, TGEs, token generating events, whatever you want to call them. How have Canadian securities regulators gone about regulating ICOs, and more broadly, cryptocurrencies and digital markets?
Sure, and I'll start off answering that question. And I'm going to really kind of go back to basics and talk about what a security is and also what our mission is as security regulators. By and large, we all across Canada have similar missions as securities regulators, and that essentially is to promote and protect the public interest by fostering a securities market that is fair and warrants confidence, but also fostering a securities market that offers investors with opportunities and also companies with access to capital. Now, when we think about cryptocurrency offerings, we can certainly see the benefits in terms of access to capital and the freedom that there is there. But at the same time, we were also seeing the risks that are inherent to these types of offerings, risks involving volatility, transparency, valuation, liquidity, custody, all these sorts of things. And what is a security? I mean, the obvious answer is, it's a common share. That's something that we're all very familiar with. I buy a share, I expect a dividend, perhaps the increase in the value of the common share. But of course, our act goes beyond just talking about shares. It covers things like bonds, debentures, promissory notes, profit sharing agreements, where you're not thinking about a dividend necessarily, but an interest payment perhaps, or some other kind of profit sharing arrangement. Then there's the concept we have under our securities rules called the investment contract. And since about the late 70s, really, the courts have looked at that definition in our act and really interpret it in a way that basically it's a situation where it makes sense for the investor protection principles underlying our securities regime to kick in and apply in that circumstance. And that's typically where we think about when we talk about an ICO or an ITO and issuance of a coin or token. We've seen a lot of great businesses with great ideas from great people with just amazing functionality when it comes to these coins or tokens. And so really what it comes down to really is we have to look at each of these on a case-by-case basis to determine whether or not we're dealing with a security here. And the way we do that is with an older Supreme Court of Canada case called Pacific Coast Coin. Many of you will be familiar with the Howey test. And it's essentially broken out into 4 prongs. There's the investment, there's an investment, and in the old days it would be fiat currency, Canadian dollars, US dollars, but now we're talking about investments I'm using Bitcoin to pay for my coin or token. The second prong is that there's a common enterprise between the promoter of the investment and the investor. So is there some kind of a alignment of interest between the two? Third, we're looking to see if there's an expectation of profit. So has the promoter provided some kind of representation or some kind of action leading the purchaser to think that, hey, you know what I'm buying is probably going to increase in value, or in some other way essentially expect a profit. But importantly, under the 4th prong, essentially this expectation of profit has to come significantly from the efforts of others. So really, when you're buying something, you're putting your money into this and kind of letting someone else, the company, for instance, really increase the value of the company. Now, Denise, you and I have been talking about these things quite a bit over the last year. So maybe Denise will just talk about, what does it mean if it is a security, and what obligations kick in if it is a security?
Right. So practically speaking, most of the initial coin offerings and initial token offerings that we've seen, they have ended up looking like we are dealing with a security. That may be because quite often we see that the platform that they're going to be used on is not fully developed yet. In other cases, their marketing around it is really focusing on the expectation of profit that people are going to get from the trading. So mostly what we've seen in this space has led us to conclude that we're dealing with a security. One other area of securities law is derivatives. So in some cases, it could be that we're dealing with a derivative as well. For example, a futures contract, where there's a contract for future delivery of a security, or it could be a commodity. So even if the cryptocurrency itself was not a security, it could be a commodity, and if there's a future delivery of it, that can trip up securities laws as well. If we are dealing with securities laws, I'm going to talk about two of the principal requirements that can apply, and I think Amy and Marco will talk about a couple others. But the first two that I'll talk about are the registration requirement and the prospectus requirement. So if you're in the business of trading securities, and the keywords are in the business, or in the business of advising in respect of securities, you are required to be registered with the securities regulatory authorities. And registration, involves assessing whether the individuals have sufficient proficiency. You're going to hold yourself out as being in this space, that you have the necessary courses and understanding of the marketplace, as well looking at certain capital requirements, that they've got adequate sort of financial wherewithal if you're going to be holding other people's money or it's going to be flowing through you. So there's the registration requirement if you're in the business, and if you are registered, you are then required to know your client, understand their investment objectives, and make an assessment about the suitability of an investment for them. The second main requirement is the prospectus requirement, and you heard a bit about that earlier on the last panel. But if an issuer, a business, is going to raise capital by issuing securities, the prospectus requirement will typically apply. So they're required to prepare a disclosure document, full, true, and plain disclosure of all material facts relating to the business, its operations, the principles of the company, the risk factors relating to the offering, and that has to be reviewed by securities regulators and a receipt issued for it before they do their financing. Securities regulators have recognized, of course, though, that the prospectus requirement can be too expensive for companies given their financings, particularly because once you do a prospectus, you become a reporting issuer. So it's not just the costs of the offering document, but thereafter you're a reporting issuer subject to ongoing disclosure requirements. So we've developed codified prospectus exemptions, and they spoke about that on the last panel. The two that we see most often being used in this space are the accredited investor exemption, and as mentioned, that would be selling to financial institutions or to wealthy individuals. In the case of individuals, most individuals qualify on the basis of having net income of at least $200,000 on a recurring basis. If you're selling to accredited investors, we don't prescribe the disclosure document that you have to provide to the investors, although there can be a risk acknowledgement form required. Most of the ICOs and ITOs are looking at doing a broader-based financing, and so they're looking at the offering memorandum exemption. Again, a prescribed disclosure document, but not quite as extensive as a prospectus, and as I mentioned, significantly doesn't result in the company becoming a reporting issuer or a public company. So that's what we've seen principally as the prospectus exemptions in this space, but we do, securities regulators have the ability to grant discretionary relief. So you can come in and make an application, and if you have alternative investor protections that you can provide, we can give you discretionary relief from some of those requirements. And maybe Marco can talk about some of the relief we've given recently.
Yeah, so a brief word on impact finance, which was the first approved ICO at the sandbox level. So impact was looking to do an ICO to raise capital, to develop their ecosystem that is dedicated to the impact economy. So basically what they did, they approached us. We looked at their business model, we tried to understand what they were doing, and we had discussed the possible ways that it could be made in compliance with securities law. So what they did is that they used the offering memorandum prospectus exemption that was discussed on the previous panel. So basically the offering memorandum was the white paper. They took their initial draft of the white paper and added disclosures and certifications that are required under offering memorandum requirements. And since the ICO was not made through a registered dealer, they applied for an exemptive relief from the registration requirement, which was granted at certain conditions. Those include that Impact performs KYC and suitability assessments. So this implies, among other, that Impact verified the identity of the purchasers, which they did through an electronic verification process. They used a third-party service provider, and purchasers were also required to fill out an investor profile questionnaire to basically make sure that they understood what they were investing in and that the investment was suitable. Another condition was the $2,500 investment limit for retail investors, so investors who are not eligible investors or accredited investors. This is consistent with Regulation 45108. That said, the average investment was way lower than this investment limit. So impact is the first relief granted. If you are looking to do an ICO, it's worthwhile, I think, to have a look at that decision. That said, every ICO we look at and every application, it's on a case-by-case basis, so you may need different relief from different requirements, and the conditions are tailored for every ICO. Of course, this applies to ICOs which are securities.
Okay, so I'll just jump in and talk a little bit about cryptocurrency exchanges, which I think most people here know about. We actually refer to them as cryptocurrency trading platforms at the OSC because they're not necessarily exchanges in the traditional security sense, but today I'll refer to them as cryptocurrency exchanges and don't tell our market regulation branch. So we're seeing a development of business models in terms of businesses coming to us wanting to establish these types of exchanges, and we're recognizing that we need to be prepared to answer their questions on what compliance might look like, or your questions to the extent that you're in the room. So really we're seeing a variety of cryptocurrency exchanges. We're seeing some that are offering for purchase and sale, cryptocurrencies that have a more established market that can be easily exchanged for goods and services. We're seeing others that are trading cryptocurrencies that aren't necessarily as established, that can't quite as easily be exchanged for goods and services, that are perhaps a little bit more novel. So this could include, let's say, coins and tokens that have recently been distributed under an ICO or an ITO. But I think what you've really been hearing here today, particularly with this question, is that cryptocurrencies can in some cases be securities, so to the extent that they are, and you've got a cryptocurrency exchange that you're operating that's trading in cryptocurrencies that might be securities, we're asking that you turn your mind to what compliance requirements might apply. Even if you're not sure if the cryptocurrencies on your exchange are securities, we're asking you to please come and have the conversation with us. We'll help you kind of make that determination in the sense of we'll help talk about what compliance structure might make sense for you. It could be marketplace rules that make sense. It could be dealer registration, a combination of the two. There could be some relief from securities laws available. It really is going to depend on your business model. So again, I think that's where the benefit of our local teams comes in, is that you can approach your local regulator and have that discussion with them about, I'm operating a cryptocurrency exchange, I think I'm caught, I think I'm not caught, let's have the discussion. And since we're answering an ICO, ITO focused question, I just want to flag for the businesses that are doing coin and token offerings that they really, or that you really should be thinking about what the resale of coins and tokens is going to look like. The last thing that you want and the last thing that we want as the regulators for you to really set up the initial distribution in a way that's compliant, like Marco described. For the initial sale, you set up really good know your client and suitability requirements. We wouldn't want subsequent investors to then turn around and be able to buy without appropriate disclosure, without having a proper understanding of what they can use the coins and tokens for, investing amounts that they can't withstand to lose. So, in addition to really highlighting for exchanges that they should be turning their minds to these issues, we also want to highlight for the businesses doing coin and token offerings. This is also a consideration for you, but again, come in and have that discussion with us and we'll help you work through it.
Okay, so we've talked about ICOs, we've talked about cryptocurrency exchanges. What about crypto investment funds? So who wants to talk about that? What the registration issues or other requirements might be engaged?
I can jump in on that. So as Marco said, we have approved 4 cryptocurrency investment funds out of Canada. These have been private funds, so that means that they've been offered under a prospectus exemption as opposed to under a prospectus document, which is what Denise was talking about earlier. So in Ontario, that typically means that securities of the fund will be sold to high net worth individuals or institutions as accredited investors. And the portfolios of the funds that we've approved have contained things such as Bitcoin, Ether, and Litecoin. We're hearing from investors that they want access to these cryptocurrencies, they want exposure to these cryptocurrencies, and we understand that investment funds of this type are a really good way for investors to gain exposure without having to go through, let's say the burden of setting up a digital wallet, of interacting with the exchange directly. We're also understanding that investment funds do have access to better pricing than individual buyers might have. So we definitely see the appeal. We see why investors want that exposure. But at the same time, we just always want to have potential risks to investors in mind when we're approving these types of offerings. So we're hearing things about the potential for a bubble. We're hearing about, lack of oversight over the markets. We're hearing about less established markets, the potential for fraud or price manipulation. So again, it's not that we don't want investors to access these products. It's not that we don't want these funds being launched out of Canada. It's just that we're really trying to take a more measured and reasoned approach. And so to that end, as I said, the funds that we have approved have been private funds. We have not to date approved any prospectus qualified investment funds. So those would be investment funds that are selling their securities under a prospectus. There are different rules that apply when it comes to public prospectus qualified funds. And there's just also different considerations, such as broader access by retail investors. That's not to say we're not actively working on these issues, working with industry, working with businesses and their professional advisors, and we're definitely continuing to develop our thinking in this space on that. So maybe, Marco, I'll turn it over to you to talk about some of the key issues that businesses who want to establish these types of funds should be thinking about.
Yeah, well, the first question, as Amy mentioned, this is a regulated area. So even if it's a private fund, if it's only available to accredited investors, and even if it only invests in one cryptocurrency, for example, Bitcoin, investment funds are regulated. So to manage a crypto fund, you have to be registered as an investment fund manager. And if you are an existing investment fund manager, you have to disclose to your local regulator that you are changing your business plan. And what we have done with the 4 crypto funds at this time, we have looked at the product, at the investment fund offered. We have looked at the firm. We have looked at the procedures that were in place to make sure that investors are protected. 2 main areas that we have focused on is custody. So custody is, of course, a big issue. There are not a lot of custodians of cryptocurrencies, specialized in cryptocurrencies in Canada. So the custodians that we have seen for the 4 funds so far, they're operating outside of Canada. So we had a look at the regulatory framework of the custodian, what requirements they were subject to in their jurisdiction. We've also had a look at their procedures to make sure that they were well adapted to the reality of cryptocurrencies. We've also had a look at the custody agreement between the investment fund manager and the custodian. So custody was a big issue. Another issue is the sourcing and the valuation of the crypto assets. So I will let Amy.
Okay, back to me. So as Marco just
These guys
said...
are just moderating themselves, by the way.
Sorry. Do you want to jump in?
No, not at all. Go ahead. Go ahead.
Making your job easy. So sourcing and valuation, as Marco said, are two other things that we're asking businesses who come to us to establish these types of funds to just be turning their minds to. So I'll talk about sourcing first. To the extent that you're coming to us and you say, I'd like to establish a cryptocurrency investment fund, one of the first questions that we'll ask you is, are you using a broker to source the cryptocurrencies? And if you are using a broker, what due diligence have you done on them? Are they reputable? Are they regulated or overseen in any way, whether here domestically or abroad? Do they have policies and procedures in place to ensure that cryptocurrencies are obtained from legitimate sources for your portfolio? Other questions around sourcing will be whether you're sourcing from cryptocurrency exchanges or whether you're sourcing over the counter. So when it comes to cryptocurrency exchanges, again, it's going to be questions around what due diligence have you done? What exchanges are you sourcing from? Are you sourcing from one exchange? Are you sourcing from multiple exchanges? Because, obviously everyone in this room is aware, or most people are aware, that there's really varying standards of oversight over exchanges, particularly when it comes to identity verification and pricing of cryptocurrencies. So we're just interested in whether or not you've turned your minds to those issues and you've really done an in-depth look at the exchange. When it comes to sourcing over the counter, there's going to be other considerations. We'll ask questions about the counterparty. Are they a large player, small player? Again, always, are they reputable? Are they actually able to provide a price that's more competitive for the cryptocurrencies? And then when it comes to valuation, again, it goes back to the exchanges, because what we do see is that investment funds typically want to value the cryptocurrencies in their portfolio against one or more exchanges. So obviously, we'll have questions around how those exchanges have been selected, whether or not they actually reflect, an accurate price in the overall markets for the cryptocurrencies. To the extent that you're doing over-the-counter sourcing, the question might be, is it appropriate to value against an exchange? So again, just a dialogue to get you turning your minds to those different types of issues. And again, because we do have a lot of areas that we're focusing on, in practice, what this means is that if you want to come in and get registered in order to establish and manage a cryptocurrency investment fund, you will most likely have terms and conditions imposed upon your registration. And these terms and conditions are meant to address key risk areas in order to make sure that investors are protected. So, we'll have a term and condition that requires you to notify and get the approval of your principal regulator before you add a cryptocurrency to the portfolio that wasn't there before. We'd obviously have concerns if you were adding a cryptocurrency that didn't have a very well-established market, that might cause issues if you had to sell to fund redemption requests. So that's one term and condition. We'd have terms and conditions around, making sure that the broker and the custodian is, someone who, again, is reputable and has appropriate policies and procedures in place. We'd have another term and condition, just making sure that the portfolio is actually, or the investment fund is actually getting a fair and reasonable price for the cryptocurrencies that it puts into its portfolio. And then we have also reporting terms and conditions, such as investor complaints. The principal regulator would want to know about any investor complaints. And really what that does is it provides the business an opportunity to work with the regulator as soon as possible to address any issues. So we're not waiting the one-year period before the traditional reporting comes in. We can work with your business immediately to help rectify any of these issues as they're identified.
Okay, so let's move to reporting issuers. We've seen a lot of companies go public in this space, RTOs. What are your thoughts, Elliot? And
Denise, sure, I'll start.
Yeah, why don't you start?
So most of the companies we've seen raising money in the space are doing the ICOs and the ITOs. So they're not raising money publicly through an IPO. They're not going public typically. We have seen some developments in that space, though, through the reporting issuer world. I think it would be interesting and maybe more exciting for the capital markets if we saw more of these companies using the cryptocurrency offerings and using them in the public markets and raising funds that way. That could be a more interesting development. But at this point, I think what we've seen is companies in a few areas, and I think we've only seen one true IPO in the space. Most of the companies are going public through reverse takeover. So they're getting taken over by an existing publicly traded company that's probably a shell. And they've been focused in sort of four main areas. One has been cryptocurrency mining. Another is investment funds, as Amy was speaking about. Here we can see companies either investing in cryptocurrency or investing in other companies that are in the crypto space or the blockchain space. We've seen some issuers in just blockchain, nothing to do with cryptocurrency. They're focusing on sort of blockchain aspects of their business and marketing on that. And I think the fourth area has really been sort of in crypto currency-related services. So that could be offering sort of cold storage, or it might be providing sort of a digital exchange. That's sort of the focus we've seen so far. We're running out of time, so I'm going to turn it over to you to talk about some of the disclosure issues. Elliot?
Sure, yeah. So, as reporting issuers, put out a lot of disclosure, either because it's in the prospectus or because it's just part of their continuous disclosure obligations, so their MD&A, their financial statements, AIF if they're a non-venture issuer. At certain points, we as securities regulators are required to look at the public disclosure. For instance, if there's a company planning on going public, if they file a long-form prospectus, of course, we would be in there looking at it, making sure there's no public interest concerns. And also with continuous disclosure, if we receive a complaint, or perhaps we have some kind of an industry-targeted review, we'll look at the CD, the continuous disclosure of those reporting issuers as well. I think we've in the corporate finance divisions of the respective commissions, we've kind of looked at a lot of these issuers. We've seen some pain points, like areas where we think disclosure can be improved for these public company, like blockchain or cryptocurrency companies. And I'm just going to really distill it into three buckets of places where we could look at, or where reporting issuers could look at to think about when they're putting together the disclosure. The first is unbalanced disclosure. When a reporting issuer provides disclosure, it's supposed to be balanced. So they're supposed to be providing information that is both positive and negative, as long as it's relevant to the company. We've seen a lot of promotional disclosure in news releases in this space. We see companies talking about thinking about potentially entering into an agreement, perhaps to implement blockchain technology into an aspect of their business. In the best case, it's probably not best disclosure practices, but in the worst case, it's misleading, and we've seen some misrepresentations made. And if something like that happens, we would want to talk to you and ask you to, clarify what you meant by that. The second bucket that we've been seeing when it comes to blockchain reporting issuers is, or blockchain cryptocurrency reporting issuers, really is around the area of describing what the business is. We've seen prospectuses that really go and don't really provide any information relevant to the company with respect to their blockchain technology. They don't talk about what it is. They don't talk about what they're doing in the space. They don't talk about how it adds value to the company. If there's an issuer, a specific issuer, affiliated issuer that's linked to this reporting issuer, who is it? They don't talk about that. So that's something else we've noticed that we'd like to, you to put your mind to when you're putting together your disclosure. And the third big bucket is really related to the first two as well, and it's disclosure of risk factors. When you're a reporting issuer, the obligation is to provide relevant risk factors as well, so that an investor knows, what is the risks of putting your money into this investment. I've seen some prospectuses with no risk factors about blockchain or cryptocurrency, and clearly, our understanding is at the point where we're aware of many of the risk factors. We want to make sure that you talk about the factors that are relevant to your business, volatility, limited history of the development of blockchain, cybersecurity, custody, liquidity issues, things like that. And like with all industry examples, we see some good ones and we see some not so good ones. We really just want you to turn your mind to the extent that you're a reporting issuer and think about some of these issues.
Okay, so final thoughts. We have 1 minute left. So what can everyone expect in the coming year to look out for from the CSA sandbox?
Sure, I think 2017 was very much the year of the crypto from our sandbox perspective. From BC staff's perspective, I haven't seen any reason that it's going to change from that, or I haven't seen a lot of files. I don't know if anyone else has any views on that, but it just seems like it's going to be some of the same discussions we've had this year, although I think we're now advancing the knowledge that we're gaining the last year. Okay, anybody else, or?
I mean, I think cryptos will continue, but I think we'd love to see other business models. RegTech solutions, KYC solutions, please come talk to us.
And I think just to echo your thought earlier, we've seen a lot of great ideas from a lot of great people on a lot of great, with their great companies. And a lot of times it is really focused on the technology side of things. We obviously have a different focus that maybe if you talk to your legal counsel and think about these securities laws issues with them, and then when it's appropriate, come talk to us as well.
I paid him to say that. Talk to legal counsel. Okay, thanks a lot. I really appreciate all your time.
Thank you very much.
Thank you.